Hello everyone, we are going to get started. Thank you for joining us at the Cancer Legal Resource Center's webinar on disability insurance. The Cancer Legal Resource Center, or CLRC, is a nonprofit designed to assist people with the legal issues that unfortunately arise with a cancer diagnosis. My name is Connor Hannigan and I'm a Juris Doctor Legal Fellow with the CLRC as well as a cancer caregiver. We record all of these webinars, so if you need to leave early or if you'd like to share this information with friends or colleagues, you can do so on our website. Some of our recent webinars have focused on healthcare reform, Medicare, student loan forgiveness, and clinical trials. If you have any questions during the presentation, please feel free to type them in the box that should be located on the right of your screen. We will leave some time at the end to answer them. One of the services provided by the CLRC is a free telephone assistance line where people can call in or complete an online intake form, ask a legal question, or describe a situation that they need some legal information on. We will call them back or email with information and resources in English or Spanish to allow them to better understand laws and protections that may assist their situation, as well as provide referrals to legal aid or other attorneys as needed. If you have any questions pertaining to this webinar or any other legal issue for which you are not already represented by an attorney, call us at 866-843-2572 or fill out an intake form online. The online intake form will result in a faster response to any questions. For many people with cancer or with a history of cancer, employment might not be possible right now. Some of these programs can seem complex and jumbled, so now I'd like to explain some of the programs that can provide you with financial assistance while you're not able to work and try to demystify some of these concepts. Generally, disability insurance is a form of monetary insurance that pays a portion of your income in the event that a temporary or permanent disability prevents you from working. There are three different types of disability insurance: private insurance plans, short-term insurance plans through an individual state, and federal long-term insurance plans. I'll go into each of these in more detail in just a little bit. This graphic does a good job reminding us that we're talking about financial assistance programs rather than health insurance, which you can learn more about on our website. It's important to keep in mind that disability means different things in different contexts. For example, the definition of disability is different for public programs, such as those run by the Social Security Administration, and for private disability insurance plans that are run by private companies. Cancer can be considered a disability for purposes of private insurance plans, short-term insurance plans, and federal long-term insurance plans. It is important to note, however, that cancer is not always automatically a covered disability, and we will discuss individual definitions for each of these programs shortly. Private disability insurance is an insurance policy that can be provided by an employer as an employee benefit, or an insurance policy that can be purchased by an independent individual. Private disability insurance provides wage replacements while you're unable to work due to a disability. As this graphic shows, although there has been an increasing trend in purchasing both short-term and long-term private disability, less than half of private industry workers actually enroll. Disability insurance usually gives you a certain percentage, often around 60%, of what you ordinarily earn during the time you can't work due to cancer or treatment. It does not provide job protection or health insurance coverage. In order for your job to be protected while on leave due to a disability, you must take protected leave like the Family Medical Leave Act, FMLA leave, use sick or vacation days, or use any leave policy your employer may provide. Often you have to both apply to receive benefits from your private disability insurance plan and request leave under FMLA or with sick or vacation days through your employer at the same time in order to return back to your position at work. Especially in the context of private disability insurance, it's really important to look to your specific policy's definition of disability. Private policies are governed by contract law, therefore terms and conditions vary by plan and option selected. For example, some policies may cover specific disabilities and not others. It's always important to have a copy of your disability insurance plan and understand the plan's definition of disability to know when and how you will be able to receive the wage replacement benefits. Because private insurance is governed by contract law, insurance companies can choose not to contract with certain individuals, or can choose not to sell individual disability insurance policies to people who have a pre-existing medical condition. So it's important to have disability insurance before you need it. While we can't go back in the past, it may be important to consider or encourage other people to consider getting insurance before you or they need insurance. If you have some form of private disability insurance through your employer, you might need to talk to the person who handles your benefits to get a copy of the current contract. In general, if you are not already covered by private disability insurance, you will not be able to get it, at least probably not at an affordable rate if you currently need it. Even if you are in your employer's open enrollment period, there are still often pre-existing condition exclusions, meaning if you sign up now, having already been diagnosed with cancer, the insurance may not cover you. It is important to find out what a plan will cover before you sign up and start paying. Once they issue the policy, it generally cannot be canceled as long as you pay your premiums, and it is guaranteed to be renewed each year. However, if there was any misrepresentation of the disability or pre-existing medical condition, the insurance company may cancel the policy based on a claim of fraud. It's important to always provide accurate information about your medical history to avoid this. In addition to reading the fine print to figure out when you're eligible for benefits and what counts as a disability under your plan, most private long-term disability plans require you as a condition for having disability insurance under their plan to apply for Social Security disability insurance or supplemental security income as soon as you're eligible to do so. These plans will also offset, in other words, reduce the amount of your monthly payment once you get this income, so it's important not to expect that you'll get both. So all private disability plans are different, and so it's important to look at your specific plan to see what that might cover. It's also difficult for us to go into too much detail into private disability plans just because there is so much variation. So we're going to move on to state disability insurance now. Some states have decided to implement state disability insurance, also called state short-term disability insurance programs or temporary disability insurance programs, by taking taxes out of an employee's paycheck. Only 5 states and 1 territory currently offer some form of short-term state disability insurance. Those are California, Hawaii, New Jersey, New York, Rhode Island, and Puerto Rico. Some other eligibility criteria is that you must have been actively working or seeking work when the disability occurs. You must generally earn a certain amount of which state disability insurance deductions were withheld, in California at least $300 in the past year. And finally, you must comply with medical certification, which varies by state. Not everyone is eligible for state disability insurance in these states. For example, California teachers have another system that they pay into. Generally, throughout the states that offer disability insurance, it's easier to qualify for state disability than for disability through Social Security. It is possible to receive disability income through Social Security through your state disability, though your state disability insurance benefits may be reduced. Each state is different. So for example, California state disability insurance lasts up to 1 year, covers about 55% of wages. The requirements are that you must be unable to perform regular or customary work and have a loss of wages, be unable to work at least 8 calendar days, you must file a claim within 49 days of a disability date, and have earned at least $300 from which SDI taxes were withheld during the previous 12 months. As I mentioned, in addition to state and private disability benefits programs, the federal government offers 2 long-term disability programs, Social Security Disability Insurance, SSDI, and Supplemental Security Income, SSI. Both programs are overseen by the Social Security Administration. There are some similarities and some differences between the 2 programs. Social Security Disability Insurance, or SSDI, pays benefits to you and certain members of your family if you are, quote, insured, meaning that you worked long enough, approximately 5 out of the last 10 years, and paid Social Security taxes during that time. The amount you receive will be based on your work history and the amount of credits you have with Social Security. It could take over 6 months to receive your first SSDI payment, so it is important to apply early. It typically takes 6 months for an applicant to receive their first SSDI check, but however, the applicant will be paid retroactively back to the date that they first became disabled under the Social Security Administration standards. If an applicant's disability began earlier than the application date, an applicant will also receive retroactive payments up to 12 months before the application date, depending on the date the disability began. Note, however, that there is a 5-month waiting period. Individuals are not entitled to benefits for any month in the waiting period. So while many people receive back pay for the time they were disabled before the application, no one receives back pay for the waiting period. Supplemental security income pays benefits based on financial need. SSI is for anyone who is age 65 or older, blind or disabled, and who has limited income and resources. The Social Security Administration pays SSI disability benefits for the first full month after the date you filed your claim, or, if later, the date you became eligible for SSI. This is in contrast to SSDI's waiting period. Whether you can get SSI depends on your income and resources, the things that you own. Income is money you make through wages and also any money that you receive through other sources like Social Security benefits and pensions. Income also includes such things as food and shelter. The amount of income you receive each month and while still getting SSI depends partly on where you live. Resources that the Social Security Administration counts in deciding whether you qualify for SSI includes real estate, bank accounts, cash, stocks, and bonds. However, the Social Security Administration does not count one house and one car. You may be able to get SSI if your resources are worth no more than $2,000. A couple may be able to get SSI if they have resources worth no more than $3,000. Again, both SSI and SSDI are administered by the Social Security Administration, so in order to receive these benefits, you must apply with them. You also must meet the Social Security Administration's definition of disability, which means that you cannot work due to a severe medical condition that is expected to last at least 1 year or to result in death. To be eligible for disability benefits, a person must be unable to engage in substantial gainful activity, or SGA. A person who is earning more than a certain monthly amount is ordinarily considered to be engaging in substantial gainful activity. The amount of monthly earnings considered as substantial gainful activity changes in accordance with the changes in the National Average Wage Index. For individuals who are disabled but not blind, substantial gainful activity was $1,090 per month or more in 2015 and will be $1,130 or more per month in 2016. The key to qualifying for benefits is to show how your medical condition is keeping you from working. That is why it is important to work with your medical providers to document your medical history. It is also important that you appeal any denial of benefits, as the system is unfortunately set up to deny people. Your chances increase greatly if you go through the appeals process, since decisions often get reversed. The Social Security Administration listings are a good source to look at the types of information that can and should be included in SSDI or in an SSI application. The listings, and this is called the SSA listings, are called they're in a blue book. They include conditions that the Social Security Administration has already determined are likely to affect a person's ability to work. The more that you can focus on the conditions that exist, and the more you can make the case that the conditions prevent a person from working, the better chance you have for an application going through the first time. If your medical record is long or incomplete, a doctor's letter can help greatly to sum up the key issues or explain what some of the lab results or other information means as it pertains to your ability to work. Your doctor should be familiar with the language in the Blue Book and mimic it when it applies to your condition. The Social Security Administration is looking for medical evidence that you are disabled, not a recommendation for the doctor that you be determined disabled. The Compassionate Allowances program began in 2008. It is a way of quickly identifying medical conditions that are presumptively eligible for Social Security disability benefits based on minimal objective medical information. If your condition falls within one of these conditions, make sure that it is obvious in your application by specifically requesting a compassionate allowance. If your cancer is one of the conditions listed as a compassionate allowance, you are not automatically granted SSDI or SSI, but it does mean that Social Security will review your application in an expedited manner, sometimes as short as 3 days as opposed to the average of 3 to 4 months, to quickly target the individuals who are most obviously disabled based on objective medical information. This website, listing the Compassionate Allowances, contains a list of cancer-related impairments in the Compassionate Allowances program. If you have a condition on the Compassionate Allowances list, note it on your application. There may not be a specific question related to Compassionate Allowances in the application, so it may be necessary to specifically state that you are requesting a Compassionate Allowance in your opening statement. Advanced metastasized cancer is almost always on the Compassionate Allowances fast track for determination. SSDI is based on your work history and how much money you've paid into the system through your Social Security taxes. Typically, the amount of your monthly disability benefit is based on your average lifetime earnings. You may receive a statement every year from the Social Security Administration that should display your lifetime earnings and provide an estimate of your disability benefits. You can also check your statement to see how much you would receive if you needed SSDI today. For instance, if you made $1 million a year, your benefit check will be more than if you made $1,000 per year. The monthly maximum benefit is approximately $2,500. In order to collect SSDI if you're over 31 years old, you must have worked 5 out of the last 10 years. Basically, you must have had a prior work history and you must have paid into the system within that time period. So if you stopped working 15 years ago, you won't qualify for SSDI, although you are still eligible for Social Security retirement benefits. Under the law, your payments cannot begin until you have been disabled for at least 5 full months. Payments usually start at the beginning of the 6th month of a disability. This is to ensure that people are not being paid out for a short-term disability. Unfortunately, you are not entitled to benefits for any month in the waiting period. For example, if your disability began on June 15, 2015, your first benefit would be paid for the month of December 2015. That would be the 6th full month of a disability, since the date of the disability started on the middle of the month. Social Security benefits are paid in the month following the month for which they're due. This means that the benefit due for December would be paid to you in January 2015, and so on. However, payments are retroactive back to the date your disability began, up to 12 months prior to your date of application. Once you have been on SSDI for 2 years, you also become eligible for Medicare, which is the federal health insurance program. But it's important to note that there is a 2-year wait there before Medicare actually kicks in. Imagine that you had a disability which prevented you from working beginning in May 2015, that you then applied for SSDI in January 2016 and were found eligible for SSDI in May 2016. Remember that SSDI payments are retroactive back to the date your disability began for up to 12 months prior to your date of application, minus the 5-month waiting period. Therefore, you would be eligible for a back payment of 8 months. That would be 12 months minus 5 months. Supplemental security income is a little different than SSDI. Where SSDI is based on your work history, SSI is based on lower income and assets. The amount of your SSI benefit depends on the state that you live in. The basic SSI check is the same nationwide, but some states supplement. Eligibility standards for SSI can make you presumptively eligible for Medicaid. Therefore, if you are found eligible for supplemental security income, you will most likely be eligible for Medicaid. In some states, you will not even need to do a separate Medicaid application, though we generally recommend applying for both at the same time where possible, since SSI applications can take so much longer than the Medicaid applications. The current monthly maximum payment for 2016 is $733 per month for an eligible individual and $1,101 per month for an eligible couple. Furthermore, where benefits for SSDI usually pay out 6 months after a disability determination, SSI benefits typically pay after the first month. You can apply for both SSDI and SSI at the same time and get an SSI check first. It is, however, possible to receive both SSI and SSDI at the same time. For example, you may have an income low enough to qualify you for SSI and have paid a small amount over your lifetime into Social Security so that your SSDI payments are also relatively low. Thus, you can receive both benefits. If you're receiving both, you cannot receive more than the maximum SSI amount in total. If your SSDI payments would be higher than the SSI amount, there is no need to apply for SSI. Remember, the limit for SSI's countable resources are $2,000 for an individual and $3,000 for a couple. Social Security Administration does have a return to work program for those people that have a temporary disability and are considering returning to work. Under some very specific circumstances, special rules allow people receiving SSDI or SSI to work and still receive cash payments until they can fully return to work. While attempting to return to work, you get to keep full cash benefits, keep Medicare or state Medicaid, and receive help with education, training, and rehabilitation. The trial work period lasts up to a total of 9 months within a 60-month period. Then you have 36 months to work and receive benefits for any month your earnings are not substantial. In 2015, earnings of $1,090 per month were considered substantial, but earnings of $770 are enough to put you into the trial work period. It is important to note that the 9 and 36-month period are concurrent. If you cannot continue working, your benefits will resume. Now, as with many of these systems, the disability system is set up so that you are likely to be denied the first time around. If you accept no for an answer, you will miss out on benefits to which you may be entitled. It is very important that you appeal a decision and not just reapply. Applying again will put your application to the back of the line, and you may miss out on some months wherein you are eligible to receive back payments. The Social Security appeals process has 4 levels. 1, request for reconsideration. 2, hearing by an administrative law judge. 3, review by an appeals counsel. And finally 4, federal court review. If you reapply rather than appeal, you may also stay at a level in the process where your application is not getting the consideration needed to overturn a decision. According to the National Organization of Social Security Claimants Representatives, no more than 37% of applicants are initially accepted. However, after appealing their claim, upwards of 54% are approved. If you appeal through the process, you have a much better chance of getting your claim approved than if you give up after getting denied the first time. Or if you're denied and your health or circumstances have changed, reapplying might be a good option for you. In some cases, hiring an attorney to assist you with your case may be the best course of action. The Social Security Administration has raised the statutory fee cap in fee agreement cases from $5,300 to $6,000, effective in 2009. That means that a Social Security attorney cannot charge more than $6,000 for their services. Here are a few of the practical aspects of applying to the Social Security Administration to increase your chances of getting accepted. Have a conversation with your healthcare provider. Tell your healthcare provider that you're applying for SSI and SSDI or for state or private disability benefits. Ask your doctor to provide you a basic medical certification or with medical information to strengthen your case, such as a medical journal article. Check your medical records to make sure that there isn't any information that might get your application rejected. For example, your doctor may have made statements on your medical record like patient is doing great, even when you might not be able to work. Talk to them about being honest but realistic about your application. Having your doctor write that you are disabled bears no evidence in the finding of disability. This is a finding of law, not fact. Your doctor needs to be as explicit as possible in your diagnosis and explaining your limitations. If you meet one of the official listings of the impairments in the Blue Book discussed earlier, your doctor should be clear that you have been diagnosed with that condition and include the appropriate level of severity. Look to other medical issues aside from cancer itself. Do you have multiple medical diagnoses? Do you have psychological and/or physical effects? Are all of these other conditions in your medical record and/or in your doctor's letter? Have you talked to your doctor about limitations you may be experiencing, such as not being able to walk more than a block without getting extremely tired, or experiencing extreme nausea or diarrhea which makes going to work impossible? Has your doctor given you additional limitations that don't appear in your medical record, such as advising you not to lift heavy objects, or has your doctor indicated that you should not be at work? You might need to make another appointment to make sure that these issues make it into your medical record. In order to qualify for these disability benefits, it should be clear from your medical record or any supporting letters from doctors that you cannot work. This is often in contrast to unemployment benefits, which require you to be actively looking for work. Therefore, receiving unemployment benefits while applying for disability insurance may not be possible. That's a question that gets asked to us a lot because applying for unemployment benefits generally indicates that you're actively looking for work and therefore able to work, while applying for disability benefits is indicating that you are currently unable to work. Here are some resources that might be able to help. You can go to ssa.gov to find a listing of impairments, as well as the Compassionate Allowances list, the Blue Book, and the application itself. Thank you for participating in this webinar. We're going to stop the recording and allow a few minutes for questions. Please remember that if you have any questions that are specific to your situation, you can either call the CLRC or fill out an intake form online and we will get back to you. Thank you. Take care.